Well, hello everyone, and welcome to a very special webinar that we're running in association with travel law specialist Travlaw as part of our Roadmap to Recovery series at Travel Weekly, designed to help you all through this COVID-19 pandemic. I'm Travel Weekly editor Lucy Huxley, and I'm delighted to be joined today by four expert lawyers who are here to give practical advice on a range of topics that are presenting challenges for the industry currently, and also to answer your questions. Now, the lawyers with me today are Senior Counsel Stephen Mason, Senior Partner Matt Gattenby, Partner and Employment Law Specialist Ami Naru, and Associate Solicitor Christine Boosfield. So welcome everyone.
Hello, good morning, Lucy.
Morning.
Now, each of them is going to do a very quick overview, a little presentation on areas they think the industry needs to be thinking about in the coming weeks. And then at the end, I'm going to bring them all together again so that we can answer some of your questions that you've been sending in over the past week to Travel Weekly. So without further ado, let's invite our first speaker to give his little overview, and that's Matt. Over to you, Matt.
Thank you, Lucy. Yes, I mean, these are just little snapshots, aren't they, of what we've been seeing from the travel industry, what they've been talking to us about. And, you know, as per usual, there's a lot going on. Some of it a little bit more positive in terms of what we're seeing and hearing in terms of the way that the markets are starting to pick up again. But that's not the focus of today. A lot of the questions we've been getting at Travlaw have, of course, centered around the issue of air bridges and traffic lights and the whole issue of getting back. We've had some semi-announcements in the last couple of days. We're really waiting for the meat of it. We kind of know what that means in terms of a legal context. It isn't that different to what you will see and read in terms of what it means to travel businesses generally. I think all you can do as businesses is just kind of keep an eye out for these announcements and try and act in accordance with them. We all know that travel businesses should act in line with things like FCO guidance and governmental advice. But of course, we've got two sides to that now. We've got the UK side of things and what they say you should and shouldn't do in terms of leaving the UK, but also the FCO advice in terms of, you know, kind of destination. But we've also got other countries as well saying you may or may not be able to enter, and those two things may not correspond. Also getting a lot of questions over, you know, lockdowns on a smaller basis. For instance, you know, let's say that countries do open up again and everybody can travel from the UK if they want. Well, not necessarily everybody, because the good people of Leicester, for instance, may not have the same kind of choice. So we're getting a lot of questions around what does that mean and what happens if that happens elsewhere. At the same time, we've still got issues such as the Competition and Markets Authority investigation, which is still ongoing, focusing particularly on the accommodation sector as opposed to package travel. And that's something which we think might start to become more of an issue going forward. We certainly think that is something that people need to keep their eyes on. General other issues for the industry is, as we try to get back to something approaching where we were, a lot of questions about, do we need to do things like changing our terms and conditions? Do we need to look at our supplier conditions? The answer to both of those things is yes, although if you had a good set of documentation in the first place, if you had all those kind of ducks in a row, then you should be pretty much good to go going forward. But it's certainly worth having a look, especially if you've got the time to do it. Other than that, seeing a lot of questions about things like kind of guidance to customers. What should we do? What kind of information should we give them about all of those things, air bridges, traffic lights, et cetera, et cetera. And of course, you know, we expect and we know that the travel industry will be able to kind of get into that and to give that kind of information in a sensible and really professional way, because it's what they're good at. It's what you guys are good at. But again, what the wording should be, whether you're going above and beyond what you should be saying in terms of, you know, do this, do that, et cetera, and the information sources which you need to point people to. So that's it from me. Very much order of the day here at Travlaw, those kinds of issues.
Okay, Matt, thank you very much. Well, we have got some questions coming up later on, inevitably, air bridges and quarantine and this new traffic light system. So you can look forward to that, but you've got a little rest for the time being, because we're going to now hear from Christine, who's going to cover off the latest on refunds. I mean, we're talking now about air bridges, and that's the current thing that we're talking about, but the refund issue hasn't gone away by any means. We're also going to talk about chargebacks, customers losing patience, of course, we know all about that. So let's hand over to you now, Christine, please.
Thanks. Yeah, it seems like a long time ago we were talking about this last, so I just wanted to give a brief update on chargebacks, statutory demands we talked about the last time, and also, yes, those refunds and the refund credit notes issue. So chargebacks still very much present in the industry, something that's not going to go away, unfortunately. We have seen varying levels of success with these. MasterCard and Visa, if we stick to the guidance that those guys put out and we quote it in our responses and our disputes, we're seeing great of success. So everyone still needs to keep an eye on those. Amex is a lot more difficult. They haven't given specific guidance. Really, they're not known for disputes well. Going for your disputes, keep acknowledging them. Don't let them, fall by the wayside. Say we're looking forward to travel. We're looking forward to the industry getting back up and running again. But these things are still going to be underlying, and we need to keep on top of them. Insurance claims also, obviously, of course, people are pointing customers towards the insurance. Insurance companies are protecting themselves and pushing back as well. But we need to keep our stance strong. We're giving refunds as and when they're due, but if customers can claim via that route, we need to make sure we're helping them do that with any correspondence or any copy documents we can issue them to support that. Statutory demands. So this was something we spoke about last time, and it's always scary if a stat demand lands on your door. We discussed about how to dispute those, how they shouldn't be used. Any that we received or any that were contacted, any of our customers that contacted us having received, we disputed them, and we didn't see any winding up proceedings off the back of those. Great. You still need to keep an eye out for them. Obviously, if they're received, they're quite a document. Today about a new act that's come into force just in the last week, and that's the Corporate Insolvency and Governance Act. Now, I'm not going to go into it in too much detail because it's a very detailed document. It details directors' duties, moratoriums, but basically it's been brought in to try and support struggling businesses as they cope with the repercussions of COVID-19. We've seen massive implications, not just in the travel industry, but throughout the whole economy. And this act's been brought in to try and help businesses through that. Two really good things that have been brought out of it. So stat demands that have, if they have been served on a company, any company, between the 1st of March and the 30th of September this year are void. So if you receive a stat demand between that date, yeah, you look surprised.
Yeah, I am.
Exactly. Yeah, so this is a bill that went through Parliament. It got approved very, very quickly, and that's because of the implications on our economy. So if you receive a stat demand dated between those dates, it's void. It doesn't count for anything. You should still acknowledge it, definitely, because if you're receiving a stat demand, something has gone wrong, but you should still acknowledge it, but it doesn't apply. It doesn't have any standing, and that's law. The same with winding up petitions, not as blanket ban, but basically if a winding up petition is presented after the 27th of April, but again between those dates, the court will very much consider the impact that COVID-19 has had on that business and why the winding up proceedings are being issued. So if you can evidence, and there's various ways a court will look at it, so they'll look at your balance sheet, are you able to pay your debts, travel companies, this sort of thing. If you can prove that COVID-19 has had a negative financial impact on your company, and the only reason you find yourself in this position is as a result of COVID-19, the winding up proceedings will not be granted. They will not proceed. So that's two really important issues to look at. As I say, there's quite a bit more to the Act itself. So if you want any more information about that, please get in touch. It was actually only made law last week, so we're all still learning a lot about it. But some great news there and some really positive steps for anyone who's worried about receiving these sort of demands or threats. The final issue I wanted to speak about, and just I wanted to give kind of a bit of advice, refund credit notes. So like I say, February, March seems like forever ago. And the first date that people were putting on their refund credit notes was payment will be made 31st of July. Scarily enough, today is the first day of July, which seems obscure. So it is becoming that date when the refund credit notes are becoming due and payment is due to these customers. So very wary that that's at the end of this month. Good news though, however, is as Matt said, now borders are opening, people are traveling again. So whenever you said to someone in March, do you want to book again? Do you want to postpone your booking? And people were saying, absolutely not. We're in the middle of a pandemic. We're never going to be able to travel again. I want my money back. Whereas now, I think if you contacted some of these people and said, oh, hello, by the way, you know, you're going to get your cash refund at the end of the month. However, you may have noticed we've got some great places in Spain, we've got some great places in France, you know, we can offer you this, maybe, you know, later in the year, it's looking a lot more likely. I think some customers can be persuaded. And again, their refund credit note, their booking is still protected. So you may be able to change their request for a cash refund into that new booking, thereby keeping the money in your business and, you know, looking forward, taking positive steps in supporting your business and the industry. So just ideas to think of as these new dates approach that we thought were way in the future, but are now on our doorstep.
You're right. I did look surprised then when you when you said some of those things. But that is good news, isn't it? So it's quite nice to be talking about some positive things, as you say. All right, Christine, thank you very much. Let's now ask Amy to talk to us. Amy is our employment law specialist. She's going to talk through just some of the main sort of employment issues that are around at the moment, given the likelihood of many companies having to restructure in the industry at the moment. So let's just invite Amy to talk to us now.
Hi, yes, well, on the positive side, I am speaking to employers now who are bringing people back off furlough and back to work, and I think that's in light of the travel climate changing daily as we speak. And you know, I've been speaking to some employers who've been saying, right, next year and beyond looks fantastic in terms of booking. It's what can we do with our staff in the next few months, because we really don't want to get rid of them. You know, we've invested a lot of time upskilling them. We don't want to put them out onto the job market, because if we can't retain them, then they're going to go and work for one of our competitors. So what I would say is that employers are not making these decisions lightly. Okay, there is a lot of thinking going on in the background, and I know that people who are affected by these decisions will naturally take these decisions personally. Okay, but let's just go back to furlough. Okay, that has really been a lifeline to many employers. It was initially introduced from March to the end of May. It was then extended to the end of June, and then extended to the end of July. And we now know that it's going to be there until the end of October. Okay, today heralds the start of flexi furlough, which basically means employers can have staff part-time on furlough and part-time at work, so that they can gradually bring them back on a gradual basis until they need them fully back at work. What that does mean for some individuals is, if they were on furlough previously and they had got their permission from their employer to get a secondary job, there may be implications on that secondary job now if their first employer is saying, right, we need you to come back to work part-time on this basis from the 1st of July. So that's something to think about. The other thing to think about is this, that sometimes there is a view that employers put employees onto furlough because it's the easy thing to do. But we've got to remember that there is a cost, there's an ongoing cost of that. First of all, annual leave continues to accrue during the furlough period. Secondly, continuity of employment continues to accrue during furlough. So ultimately, if there are redundancies to be made, those redundancy calculations are going to be more expensive. Okay, so it's not a cost neutral basis whereby let's just put staff on furlough and worry about them later. That's not the case. Okay, as I said, the good news is that some employers are now bringing their staff back to work on a part-time basis with a view to gradually increasing those hours so that they can get those staff back to work on a permanent basis. What employers are also thinking about is that employees will have accrued a substantial amount of annual leave. If they've been on furlough from the start of March and they are on furlough right the way until the end of April, if we consider that they probably accrue 2 days per month, that's 16 days worth of annual leave. So let's not be surprised if employers start to ask employees to take annual leave whilst they're on furlough leave. Ultimately, and if I'm being completely honest about it, there are going to be more redundancies within the travel industry. Okay, some employers made those redundancies right at the beginning of this COVID-19 outbreak. Some have had to sit tight and say, well, can we get through this? Can we get through this? How long can we get through this? And the contributions from employers will start to increase from August, when employers have to contribute national insurance contributions and pension contributions. That may be a trigger for some redundancies. From September, there's a 10% contribution, and from October, there's a 20% contribution. My personal view is that there's not going to be one cliff edge in terms of a month when these redundancies are going to be made. I think it depends on each particular employer's circumstances as to how long they can continue to have their staff on furlough, or indeed how quickly the signs of recovery for that particular organisation kick in. And what I think is really important to emphasise is if an employer puts someone at risk of redundancy, it does not mean they are going to be made redundant. The operative word there is risk, okay? And the whole point of consultation is to avoid a redundancy situation, okay? The way that an employment tribunal will view this is that redundancy is the last resort. What did the employer and the employee, and it's really important to emphasise that it's a two-way consultation process, what did they explore as a means to alternatives to redundancy? Now, employees are probably thinking, well, actually, this all falls on my employer. What can they suggest? Well, actually, no, it's a two-way process. You know, can you take unpaid leave? Can you take a sabbatical? Can you take a job cut? Salary cut, a reduction in hours? Open up dialogue, okay, because it's going to be for a temporary basis. The industry is going to pick up, and it's a question of when, okay? So enter into that consultation and don't go into it, either party, thinking it's a foregone conclusion that the word redundancy has been mentioned, so that means redundancy is going to be the outcome. As I said, unfortunately, some employers will not be able to avoid a redundancy situation. And in those situations, things that employees can think about are, right, I'm going to be put onto the job market. There aren't a lot of jobs out there. How do I make it as easy as possible for me to be able to get another job? Most senior individuals within the travel industry will have restrictive covenants, okay? Most employers will want to stand by them, but now maybe as good an opportunity as ever to approach your ex-employer and say, look, you know, I've been made redundant, I've got an earning to live, I've got a family to support, ordinarily I would come to you, but is there any way we can look at relaxing these in some way, shape or another? The employer may turn around and say, absolutely no way, okay, but what harm is there in you approaching your employer, ex-employer? Likewise, make life easy for yourself as much as possible. Instead of, you know, a prospective employer approaching your ex-employer and saying, right, we've got Joe Bloggs who's been offered a job, what have you got to say? There's nothing to stop an ex-employee going to their employer before they leave and say, right, I'm going to be put on the job market, it's tough out there, can we agree the wording of some sort of a reference now, whilst it's all amicable, because that's going to put me on the best foot in terms of finding a job moving forward. Finally, what I would say is that the duty of confidentiality exists post-employment as well as during employment. So no matter what happens, those duties of confidentiality are still going to exist. So a few things to think about there. It's not all doom and gloom out there. There are signs of, you know, definitely employees coming back to work and increasing their hours. So let's see what the future brings.
Okay, Amy, thank you very much. I mean, it is a really worrying time for people, and I thought it's really interesting that you're saying that people not to take it personally, and also not to jump to the conclusion that it automatically, if you're at risk, you're going to be made redundant, and there are sort of things you can do. So great advice there. Thank you, Amy. Last but not least, we're going to get Stephen to come to the fore. Stephen's going to talk to us about liability in a post-COVID world and the legalities of social distancing and subrogation and frustration issues that we've been seeing. So good luck with that, Stephen.
Thank you, Lucy, and hello everyone. And how nice it is to be talking in a world where things are looking a bit brighter, travel is opening up again, and I see the economists are also saying there are signs of the recession being a V-shaped one, which the country bounces back from relatively quickly. So signs for optimism. So if travel starts up again now, what is the situation with regard to the consequences of the pandemic? There are two different aspects of this I'll look at. One is ways in which holidays may be different from what people have been used to in the past. And the other is, what if people actually fall ill while they're on holiday? What's the situation there? Right, so first of all, holidays are going to be different. As you know, if there is a significant change to a holiday arrangement, you're supposed to tell consumers about that before departure, and they have various rights to either a replacement or compensation or a refund under the package travel regulations. So are these things significant changes or not? Well, in my opinion, things like socially distanced sunbathing or staggered meal times at hotels, so that there are fewer people in the restaurant, those things are not significant changes. They're purely common sense ways of providing the holiday in line with what's best for everybody's health and safety. If a swimming pool is going to be closed because it's not considered hygienic to allow swimming, that is more borderline, and it could be potentially said to be a significant change. So that's one to think about. Other issues that have been brought to me, for example, holiday includes a transfer, the classic transfer between airport and the hotel or the accommodation. The client approached me. They normally hire a minibus that will take 8 people to their destination or 10 people, but now they're only allowed 4 people in a minibus by the local regulations maximum. Who has to pay for the additional minibus which is going to be required to take these 8 or 10 people? And can they charge the consumer extra for that? Well, I'm afraid not. They can't, and that is going to be an expense of reopening up the market. Of course, for future bookings, it can be priced in, but for existing bookings, I'm afraid you're stuck with it, and you will have to make the transfer happen by the most efficient way that you can. So that's one aspect. There are 1,000 questions you could ask, and maybe there will be some questions later on this. But turning to the other thing that worries tour operators, what if people go on holiday and then they catch coronavirus while they are on holiday? Will there be a flood of claims against companies arising from that? In my opinion, that is not something to be worried about. It's something to be conscious of, but not to start getting worried or anxious about. In order for such a claim to succeed, a consumer would have to show 2 things. First of all, they would have to show that you and your suppliers have been negligent. And in this context, what does that mean? That means that you and your suppliers didn't follow the protocols, best practice for keeping people safe and healthy during the pandemic, cleaning regimes and social distancing regimes, and so forth. So as long as you follow what is the requirement in that country and what is best practice in that country, then you won't have been negligent and there won't be a claim. But even if you fall foul on that score, what the consumer still has to prove is what lawyers call causation, or in plain English, they have to show that they caught the virus out of some service that you provided, and not merely from somebody they met or a surface which they touched somewhere, or whatever it might be. And I think it will be quite difficult, if I'm honest, for consumers to be able to demonstrate that the cause of their illness was your service and no other cause whatever. So I would not be, so as I say, I would be aware that claims are possible, but I certainly wouldn't be getting anxious or worried about them. There are, of course, insurance aspects to this as well, but probably if that's questions on that later, I'll talk about that later. So, moving on. One thing, changing the subject completely, one thing we're beginning to see is claims, subrogated claims, principle of subrogation. What on earth does that mean? Well, we've already talked about that when you are asked for a refund, there is no harm whatever in asking people to go to their insurers, their travel insurers in the first instance, and asking for a refund from their own insurers. And that often works, sometimes doesn't. But where it has worked, that isn't necessarily the end of the story. If, for example, under the package travel regulations, you should have given a full refund by law, but the consumer has gone to their insurance company and the insurance company has paid them out, the insurer is entitled to bring a claim against the tour operator for the money which they've had to pay to the consumer, because that money, the consumer could have claimed that money against the tour operator. And that's what's called a subrogated claim, because the insurance company can bring that claim in the name of its insured, the consumer. And the phrase often used is standing in the shoes of its insured can bring a claim against you. So we're beginning to see a number of these arising. Of course, you will have the same defences against such a claim as you would have if the consumer had brought the claim. To give just one example, if at the time when the consumer cancelled, there was a realistic hope that the holiday could still go ahead, then the consumer was liable to pay your cancellation charges, and therefore any claim by the insurance company against you is likely to fail. So that's just one example. So just watch out. If you're getting claims from the insurance companies on this basis, I would recommend that you take advice, but don't despair. That isn't necessarily the end. There are arguments available against it. Finally, I want to touch on the subject of frustration, because of seeing this word used a great deal currently. Misuse quite a lot, in truth. So, as between package holiday consumers and tour operators, the legal concept of a contract being frustrated doesn't arise, because the rights and obligations of the parties are set out in the package travel regulations, and that's the end of the story. Where it's not a package, then it's possible, if the contract terms don't deal with the situation, that say that the contract is frustrated. What does that mean? It means that a refund is due, but the trader is entitled to deduct such wasted expenditure, which is spent trying to make the holiday happen, before making a refund, if it is fair and just to do so. So it's possible to run that argument. Of course, you will then run into arguments saying, well, the Competition and Markets Authority say it's unfair, so it's unfair and unjust to make these deductions. But that's an argument which can certainly be argued about, and it's not an open and shut case. Where frustration is more important and has more of a role to play is in contracts with suppliers. If the contract with your supplier doesn't deal with what happened in a situation like we're facing, or have been facing for the last few months, then it's possible to argue that the contract is frustrated, that the supplier should give you a refund, but subject to deducting any wasted expenditure which they've had. So that's a little bit about when frustration is and is not something which a word you should be using in various contexts.
Okay, I've learned new words today. I'm sure everybody watching this has as well. All right, great overview, guys. Really appreciate that in all your different areas of expertise. Are you happy for us to go through now some of the questions that we've had sent in by Travel Weekly readers? I mean, they're not in any order or any sort of themes. I'm just going to literally rattle through them if that's okay with you.
Yeah, bring it on.
Okay, so first one is from a tour operator who says, we take our responsibilities seriously in relation to client safety and would value the panel's view on any further specific action we would need to take under the PTRs relating to how much advice and information we would be obliged to provide clients on a particular country or destination on how they are implementing prevention protocols for visitors. And then they're saying, and what impact would there be if it was found to be inadequate? So it's how much information do they need to give for the specific destinations, and what happens to the tour operator if they don't give enough?
Okay, I'm happy to take that one. It's a good question, and everyone should be thinking about this. This is essentially an extension of the normal rules. Under normal circumstances, whatever normal is, there is that obligation on travel businesses to make available the resources that customers need to be able to assess what their own passport requirements are, what their visa requirements are, and what their health and safety requirements are. That has just become a heck of a lot more complicated because of all this. I mean, you know, we've been using, for example, the of maybe getting a train from London, cross over the Eurostar into France, and then kind of, you know, onwards to wherever, maybe to Germany, maybe to, you know, all down through to Italy. All right, you might be changing trains and whatnot. And on that one journey, you might have different countries requiring different things, such as, you know, do you have to wear a face mask on what is effectively public transport? And that can change all the time. So as a travel business, you can't be expected to know exactly to the day and to the hour when, you know, you might have to put a face mask on, whip it off, what will happen if you don't, and convey that to customers. You just have to be able to point them in the direction of where that information is available. So again, largely you're talking about things like the Foreign and Commonwealth Office website and their ever-changing resource on all that kind of things. So we've seen a lot of clients create their own little, maybe on their website, a specific page about, you know, the products that they are offering, because obviously if you're a specialist in a certain destination or something, you can do a little bit more in terms of what you are aware of. But I think that basic process is the same as it's always been, and that's what you need to be doing. Give customers the ability to kind of find that easily and quickly, and just give them as much heads up as you can. And again, if you have the resources, if you have the ability, and we know that's been difficult recently, if you can kind of send some kind of information pack out to customers and say, look, this is where you want to be looking for your trip to Cuba, to Australia, to, you know, wherever. These are the kinds of things you need to be thinking about, and here's the history. They're going to welcome that, they're going to want that, they're going to see that as definitely added value. So anything along those lines. If customers ask you specific questions, then you have to be wary about giving specific answers, because that's the only time when really you can be held to it. So got to be careful about that. And again, just make sure you know where you need to be able to look to give the answers, and don't be afraid to say, well, you know, this is an ever-changing picture. You as a customer need to check with your GP or with the FCO website.
Okay, all right. Thank you for that, Matt. Good advice. This is a bit of a complicated question, but as I say, I'm just going through in the order. We are a small independent tour operator offering tailor-made tours. Our booking conditions state all deposits are non-refundable due to the extensive work that goes into designing tailor-made trips. If we refund cash minus the deposit previously, the client could claim that loss from their travel insurance. But travel insurance companies are consistently denying claims at the moment, stating the costs are recoverable due to the PTRs. Our contract says they're not. So can travel insurance companies really deny a claim on the basis the client has the option to start legal action to recover this from the travel company?
I'll have a go at that. Right. First of all, what claims travel insurers are obliged to meet depends entirely on the terms of the policy they have with their consumers. And they have to pay out whatever they've agreed in the policy they will pay out. They have to pay out to consumers, and that's as simple as that. Subject to the comments I made earlier about subrogation. As far as deposits being non-refundable are concerned, if we're talking about package holidays, and it sounds as if we are with tailor-made tours, then I'm afraid that the package travel regulations say that you cannot, by booking conditions, make the consumer's rights weaker than the package travel regulations actually provide for. And since the PTRs say that in the event that the holiday is cancelled by a tour operator who can't go ahead because of COVID or any other force majeure type reason, a full refund is payable. I'm afraid even if your terms and conditions say different, it's overridden by the PTRs. Sorry.
Okay. Well, that's your view. All right. Thank you, Stephen. Now there's a question on commission clawbacks. So this agent has said some tour operators and cruise companies will pay full refunds, including the travel agent commission. We know that's been happening a lot in cruises, they say. Then they're saying, but others don't. There appears to be no debate on this. It all seems to be a bit of a taboo subject in the travel trade. It's a case of everyone has their own view on this matter, whether they do it or not. So according to existing law on agency agreements and or any other rules or regulations, what is lawful or unlawful with regards to commission clawbacks if a holiday has to be refunded for a reason which is not the travel agent's responsibility, as he's not the principal? So, because it is true, we've got some companies giving full commission back and others not doing that at all. And is there any kind of law on it, or is it literally just decision of the company what they want to do?
There's no law on it, so to speak. It's very much a question of what's in the agency agreements between the tour operator and the agents. There's no way to get around it. This is a very tricky subject, which I know there is a lot of passion and emotion about. But the simple fact is, if tour operators are having to give a full refund to customers for all the reasons we've decided, it means a full refund. So they're having to give whatever the ticket price was, or the invoice price was. That's it. There can be no deductions. So generally speaking, is my experience, and I think the rest of the team will agree with me. This will be a good test, won't it? Is that the agency agreements will provide for that and say, well, look, if we, the tour operator, have to give a full refund on these kinds of situations, that includes the commission. So, because otherwise the tour operator pays a full refund and the commission and loses out even more. And they will have, in these kind of scenarios, as an equal argument as the agent say, well, it's not our fault either.
Yeah.
So usually that's how it works. So if the holiday has to be refunded, that includes the commission, and so the commission will be how it's done technically, whether it's a clawback at a later date on a kind of invoicing system, etc., or whether it's done on a one-by-one basis, or whether the agent effectively says to the operator, well, look, you give us the £900 and we'll give the £100, the kind of to make it to £1,000, etc., it doesn't really matter as long as it happens. But that's how it is, and that is all down to what's in the agency agreements as to what it says. If the agency agreement says otherwise, well, then that's the position, and that's what the two businesses need to be looking at.
And so going forward, should they? I mean, do people just need to be much more diligent over their agency agreements, really? Do they just need to make sure? I mean, I guess some people they should know, shouldn't they? But they've probably got so many different ones with different suppliers. Perhaps they just don't know exactly what's in the terms.
Possibly so. I mean, there are basic standards that you would expect and things that you would expect in any agency agreement. They should effectively be the same, albeit individual commercial terms might differ, of course. I mean, look, we're the lawyers, we're going to say this. There are few more important documents than that one. Whether you're an agent or a tour operator, it dictates exactly what will happen and what the commercial terms are and the business between those two businesses. So, all too often, we see situations where no one really knows what's in them, what the situation is, and then they seem surprised when something like this comes up. And all right, we get it. The simple fact is, like with so many of these kind of documents in life, you don't want to be looking at them. It generally does mean something's gone wrong. You want to be just getting on with business. But nevertheless, the answers are usually there. And we're seeing a lot of interesting conversations about how that might work in the future, because, of course, both agents and tour operators are going to have a view on that going forward.
Okay, thank you, Matt. All right, the next question is a clause removing liability in pandemics legally binding in light of the CMA advice for accommodation only, or would consumer legislation overrule it? Oh.
That's an interesting one. Can you just repeat the question? That was
Yes, I'm not. I mean, I'm reading it as it was sent in.
Yeah.
Perhaps I'm not reading it. Is a clause removing liability in pandemics legally binding in light of the CMA advice for accommodation only, or would consumer legislation overrule it?
Yeah, I think that would be, you can't exclude liability for negligence or your responsibility. So I think that would be very difficult to get around. And I think, yeah, that may be found to be an unfair term within a contract. Exclude liability for your own negligence. So if you do something wrong, you say, you know, I'm not responsible if I do X, Y, or Z, and that's a result of your own negligence, it won't stick. So you can put it in there, but I don't think if it ever turned up in front of a judge, I don't think you're going to be successful in relying upon it.
Okay, so don't bother.
It's a tricky thing, is this? I mean, you know, this is a good time as any to mention the CMA investigation. I think there is, we're all very much, you know, absolutely, you know, as you would expect, focusing on what's going on right now and just kind of trying to recover from the past few months. So the CMA thing, to a certain extent, we can kind of like put to one side for a second, but it's happening. And that could create quite a few ripples, I think, in terms of going forward. So they've clearly got some very specific ideas, which it's hard to know because we're at the very start of their process, but I suspect that many parts of the industry won't necessarily agree with. But we'll have to wait and see. So definitely something to keep an eye on.
Okay, we will. We will be following that very closely. Amy, this one might be for you. This person says, we have had a company-wide restructure resulting in huge redundancies, but pregnant ladies have been mapped into roles, even though they scored less on the scorecard. I don't know what that is, but is this allowed?
Yeah, pregnant ladies have positive discrimination in their favour in that they should be earmarked for any suitable alternative employment. So in a short answer, yes.
So it is allowed?
Yes.
Okay, all right. Short answer, we like those. We can get through some more. Right, next one. What are your recommendations for defending a court claim for non-payment of a package holiday within 24 days? Our business is waiting on suppliers and flight consolidators to refund, so cannot pass this back before the refund is given back.
I'm guessing it means 14 days, no, it's 24 days. So
well, they say 24, but 14, yeah, that's the standard thing.
Yeah. So we've seen a few of these. So the package travel regulations state that if you cannot provide the holiday, entitled to a full refund, and that's to be paid within 14 days. Obviously, in light of the epidemic and everything we've been going through at the minute, for the majority of people, that hasn't been possible. Court claims have been issued, and yeah, we're defending those as best as we can. We can't deny that that responsibility is there, but we're obviously stating that these are extreme circumstances. We've offered alternatives. We've offered alternative dates of travel. We've offered a refund credit note. So the customer does have their money protected. It is sitting there. It's just that we can't provide it in a cash refund. And further, we're saying that at this moment in time, they haven't suffered a loss as such because their monies are protected by way of that refund credit note. We're making clear that we're not saying you're not entitled to a full refund. You know, if we admit that, we're saying that. We're just saying because of the circumstances, it may take longer to pay that out. So it's very difficult. We can't say that we're not responsible for it because that would be incorrect, but it's about working around and kind of explaining our position and why we are where we are. I think we mentioned previously, court cases at the minute, courts aren't hearing such a backlog. So if somebody issues a court claim today and you receive a claim form, it's probably not going to end up in court this year, realistically. So whilst you can enter a defence and you can kind of put the matter on hold, chances are, hopefully, you will actually be able to pay them the cash refund, which they are
by
due
the time this
before it gets to court. Yeah, there may be a small court claim that fee that the customers had to pay £70, maybe £100, that you would then pay them on top of that, you know, to say sorry for the delay and sorry that you had to go down the legal route. But hopefully, because of the time lags, it'll all sort itself out before we get to court. But any help in defence.
And are you seeing quite a lot of these? I mean, is this happening quite a lot, or?
Yeah, we're not, to be honest, we're not seeing as many as I thought we would. And I think that's because, honestly, the people are being reasonable. And travel companies are dealing with their customers. They're being honest, they're explaining the situation, they're being reasonable. And like I say, we're not saying you can't have your money. We will give it.
You're giving all these other defences, aren't you? And
case of time. So we're seeing a few, we're defending them. And like I said, it's going to be a long time before we see any in court.
Okay, great. Thank you. Back to you, Amy. This person says, my employer is forcing annual leave without topping up the pay when on furlough, and instead giving annual leave back to make up that 20%. Does that make sense? My employer is forcing annual leave without topping up the pay when on furlough and instead giving annual leave back to make up the 20%. Is this legal?
Yeah, I'm not sure I completely understand that question, if I'm honest with you, but in essence, if someone is on furlough, an employer can request that they take annual leave, and they 80% would have to be topped up to make sure that that individual gets their normal pay for any period of annual leave. If you go back to the bank holidays that were previously over Easter and the bank holidays in May, where there was uncertainty about whether you could take annual leave over furlough, retrospectively what's happened is if the bank holiday or Easter Monday formed part of their annual leave and the employer didn't top up the wage, what they've done is give them a day in lieu to compensate them for the fact that they should have had annual leave on that day that they haven't. So either the employer is forcing them to take annual leave, in which case their wages need to be topped up, or they can give them a day in lieu of that annual leave. But I'm not sure if I completely understand what's happening in that situation.
Okay, all right. Well, look, there's another one on annual leave, so let's move on to that, and maybe it will help answer that question. It says, my employer has forced me to take annual leave because I've been on furlough, but it has not been forced on those who have not been on furlough. Is this legal? And they add, I have only been furloughed for the minimum time of 3 weeks. The rest of the time I have been working.
Yeah, the fact of the matter is that an employer can request that an employee takes annual leave on certain dates by giving them double the notice of the actual annual leave that's been required to take. So yes, just because they've done it to you doesn't mean that they have to do it to everybody else. They look at each case on its own particular circumstances. So yeah, employers can force employees to take annual leave on certain dates.
And for certain individuals, it doesn't have to be the same for everyone. Okay, all right, thank you. Hope that answers your question. Matt, here's a question on traffic lights.
Yay.
I am really confused about the government's new traffic light system. If I send my client away to a green destination, but its status then increases to amber or even red while they're away, and then they have to quarantine on their return, is there any comeback on me, and can they make any claim for compensation against me? What should I be doing at the point of sale of the holiday to ensure I am not at risk?
Okay, first of all, I don't know if you're naming names on this, but feel free to, because that's a smart question. That's the question that everyone should be thinking about, really, in terms of this whole traffic light question. We don't, I mean, again, putting aside, we don't know the full details about how this is going to work, but it seems fairly simple. I think we can assume that, like, we're basically going to paint other countries in a colour. You know, red, don't go, and quarantine will apply, and then green and amber, you can go. So we're not quite sure what the difference between green and amber.
I was going to say, what is the difference between, you know, should you be more concerned, presumably you should be more concerned sending someone to an amber destination, although
well,
the consequences are the same for green and amber.
This is the thing, and perhaps we have to leave it to greater minds than ours that clearly know what that's all about. But yes, you would assume that an amber is more likely to turn into a red than a green, but I don't know. It seems to me that things can change so quickly that you could easily jump between a green and a red quite quickly. Anyway, simple fact is, I can't help but think that, you know, with any kind of opening up of things, there is going to be not necessarily a spike of, you know, cases, whether it's here in the UK or abroad, but there is a good chance that a green is going to go red or an amber is going to go red. So, you know, we're loading up with customers to send them to, let's pick on somewhere, the Canary Islands, right? Good destination to go to, sunshine, all that. That's a good end of summer potential destination. So we get loads of people booked, and then for whatever reason there's a spike and suddenly it goes red. What happens? And as your viewer has asked, that's the question. Now there is a very real problem here that certainly tour operators are going to be landed with the obligations to potentially get people back or to give refunds because they can't travel anymore, kind of, and we're back to where we started in this whole thing, and that's not going to go down well. Customers are not going to be happy because they're not going to be able to travel after all, having been G'd up to go, and there's no obvious way around this. So it's very, very difficult. So we have to be prepared for that. Can you avoid liability for that? Well, again, kind of as we've mentioned before, as Stephen touched on, you know, where's the negligence here? What did the travel business do wrong? Nothing. So it's not one of those situations. But nevertheless, you still may have the obligations. Our agents don't need to worry about that kind of liability too much because all they were doing,
the tour operator would have the responsibility to get people home and to refund. So for the actual agent selling the holiday, they did it in good faith at the time on the advice that was there from the government.
Yeah. I mean, yeah, again, save the kind of ridiculous situation that would never come up, whereas, you know, you knowingly sold a red zone when, you know, etc. And that's not going to happen. But you can imagine customers say, well, hang on a minute, I booked a holiday yesterday and you told me it was safe to travel and now it's not. And, you know, assuming that the answer is, well, that's because at midnight the government changed its categorization. There's not a lot you can do there. But the tour operators, the travel businesses are going to get stuck with that. I don't know. Is that going to happen? Are we really going to see classifications changing that much? I like to think that. I mean, if nothing else, think of the political ramifications.
I think it's even happened this week with people selling holidays to Greece, thinking it would all be open from the 6th. And then, of course, they've said they don't want Brits till the 15th. So there's even people due to travel. And I think there's been problems already because of that situation, hasn't there?
There is. I mean, if anything, that's slightly different because that's the other thing to worry about, which is I wonder if the UK applied this classification system to itself, would we be a red, green or an orange? But that's a different thing. You know, we're setting up all these air bridges, but what we're not factoring is that the countries may not want us for the same kind of reasoning. So you've got to be wary about that. These things have to be in place. And that's why I say you've got to watch out for government advisories. And it's not just necessarily the UK government's advisories that we need to be looking out for. Because at any minute, the UK may say it's fine to go to the Canaries or to France or to wherever, but they may turn around tomorrow and say, actually, no, it's not. Then what do you do with your booking? Very, very tricky.
Well, hopefully maybe we'll hear a bit more tomorrow when we're expecting a little bit more on the list and what it all means. So, okay, tricky one. Thank you for that, Matt. Let's move on to credit card fees, shall we? This is from they just call themselves a worried agent. We have been losing thousands in credit card fees, which are being charged not only for the cancelled booking, but again for processing the refunds. So as we lose the commission, we're essentially paying to book and refund our clients. Are there legal grounds to challenge any of these fees with the credit card firm?
I've heard this from a few people. Yeah, they are charged both ways. I haven't looked into the technicalities of it, but if that individual wants to get in touch, I'm happy to do so. So I don't know anything that says they can't be done, unfortunately, but by all means, if
the card companies are within their rights to charge twice.
Yeah, but if you,
and it would have to be on a case-by-case basis to see if you could challenge that.
Absolutely, but whoever that is worried, whoever, drop me an email, we'll look at it. I'm happy to because I'm interested in it as well.
Okay, all right, well, thank you for that. We'll make sure your details are available. Okay, let's move on. It's another employment one, Amy. I work full-time and currently I am furloughed until further notice. My employer has put us at risk of redundancy or offered that we can go self-employed as a partner on a commission-only basis and have to pay them a monthly fee. Where do I stand with this? They are currently advertising externally for new recruits for these roles too, yet our job descriptions will be exactly the same. And that's quite a specific one. It might be difficult to answer, but...
What I can say is this, that for a redundancy situation to exist, there has to be a diminished requirement for the work that's been undertaken. In that situation, it sounds like there isn't a diminished requirement.
So they can't then go and advertise a similar role, or they're saying exactly the same?
Of it, yeah.
Okay, so they would have a case there. They could go back and they could challenge that.
Well, I think I'd have to know all the facts and circumstances, but the key there is there a diminished requirement for the work?
Okay. All right, thank you for that. It's another one on furlough. I'm currently on furlough, very worried I'll lose my job. oh, this is a bit tricky. Do you know the rough dates each month that we would be advised by if we are going to be made redundant? I.e., would we have to be told by mid-June if they wanted to get rid of us by the end of July? If there's like a 40, it depends on the length of the consultation, I guess.
Yeah, it depends on the length of the consultation. So if there are 20 or more redundancies within an establishment within 90 days, it would be a 30-day consultation period. If there are 100 or more redundancies within a period of 90 days, it'd be a 45-day consultation period. However, if the redundancies overall are less than 20, then that consultation could be a week or 2 weeks, okay? But what the trigger point is going to be for each organisation and each employer is going to be very different, isn't it? Because there is a gradual increase in contributions towards the furlough scheme from August onwards.
Yeah.
So, you know, some might decide come the end of July, right, that's the point we have to make redundancy. Some may say end of August or when they have to start.
Yeah, it's very difficult. I think people feel it's hanging over them and they want to know, you know, at what point would they be told if that is going to, you know, back to your original point, you know, they feel it's inevitable, but you're saying it isn't necessarily, and it will be dependent on each company.
They're looking for certainty there because of their own personal circumstances.
Yeah.
What I can say from the other side is advising employers that they don't have that certainty themselves. They're trying to, you know, think about this on a daily basis and a week by week basis where their strategy is changing. So unfortunately, they can't give you pinpoint answers.
Okay, all right, Amy. Stephen, this one might be for you, but you can always deflect it if you don't want it. Are there any notable changes to refund terms and conditions for holidays booked post-lockdown? For example, if a tour operator extends its suspension of tours affecting a booking made in June rather than a booking made in January, will the customer booked in June have less entitlement to a refund because it was expected? This is a post-COVID world question. What's going to happen in the future?
Yeah, this ties in really with something Matt was saying earlier about reviewing contracts. It is important for people to look at their contracts with consumers, their booking conditions, and with suppliers and with agents. But the suppliers and agents ones are much more able to be changed in favour of a tour operator, potentially to protect against these situations, than the consumer terms. The booking conditions with consumers are pretty well, if we're talking about packages, they're pretty well laid down by package travel regulations. And therefore, the entitlement to a refund applies by law, not by your booking conditions, but by law, unfortunately. And so the law hasn't changed. You know, if we think back a few months, there was all that pressure on the government to change the package travel regulations.
Yeah.
To make it easier for the industry to live with. And the government made various announcements that might be coming, but they never did. And so consequently, we're stuck with the regulations as they always have been. And I'm afraid that means that the consumer rights today are the same as they were in January. Okay,
all right, thank you for that. I'll stick with you, Stephen, but I think you may have probably answered this in your little, you know, your presentation, but it said there's a big concern among us agents that customers will come back from holidays and claim their trip was not what they paid for because of social distancing measures, etc. If they claim a partial refund on this, what should we say? I mean, you pointed out that they'd probably, you know, I know you said swimming pools was a bit, you weren't sure, but things like just a bit more space in restaurants, that's not a significant difference. But if it does come back to the agent, can they just say that's not a claim?
I think they can, basically. It depends on the precise facts, of course. But what I would say is that as far as possible, and as my colleagues have said, it's a fast-changing situation, hard to keep on top of. But as far as possible, if tour operators or travel agents are able to pass on to consumers the latest information they have about what to expect in resort, then that will help to avoid even any claims being brought. Because there are two things, aren't there? If a claim is brought, can you win it? Yes, probably you can. but then that's a pain and expensive and annoying. So can you prevent the claim happening in the first place? Well, the way to do that is by keeping consumers informed as well as they can. And can I mention something in particular? Matt mentioned Leicester as an example of the sort of problem that can arise. So in some destinations, there will be temperature checks at the arrival airport.
Yeah.
And it would be sensible to, if you know this to be happening, it would be sensible to alert consumers to this in advance. Because, for example, if you live in Leicester, you know, there isn't, forgive me, but there isn't a kind of Donald Trump wall around Leicester. You know, anyone in Leicester can get in their car and drive to an airport and probably get on an aeroplane when the rules change, as we hope they're going to in the next few days. But if they know that there's going to be temperature checks and they know that they're ill, you know, it will prevent these sort of very difficult situations arising. If you say to people, you do know there's going to be a temperature check when you get to the destination airport, this is in the interests of the health and safety of everybody, including you, and discourage people from travelling when they shouldn't.
Yeah, so just being really aware of all the different things that are happening in resorts and being aware of different rules, etc., and protocols at different countries and different airports.
Yeah.
Okay. Is it an insurance question? We've been reporting on all these companies that have been coming out with COVID cover in their insurance policies, but this reader asks, should I refuse to sell a client a holiday until I have seen that they have taken out insurance that includes coronavirus cover?
Well, so I'll take that one as well. The answer is it's up to you whether you refuse to take a booking or not, but you don't have to refuse to take the booking. What it would be, because if people insist on travelling without insurance, in a way that's their prerogative.
Yeah.
But what you should make sure you have done is advise them that they really ought to take out cover. The better policies which used to cover illness and medical expenses prior to this, and for a period of time they dropped a bit for COVID, but mostly they're coming back on stream now to include medical expenses for COVID illness while in resort. It would be advisable to have such a policy before you travel. So if the travel agent is telling people that and evidencing that by a note on the booking file or whatever, so they can show that they did give that advice. If the consumer, in the face of that advice, says, "No, you know, I'm not having anything to do with that, I'm going to go anyway," well, that's on them.
Okay, and they should make notes in there on their booking. I think that's a good idea. All right. Sorry, Amy, back to you. I've read that some companies like Carnival UK are offering unpaid sabbaticals to employees to help them through the crisis as an alternative to making people redundant. Is this something that I can suggest to my employer to save on my salary for, say, 3 or 6 months to ensure I still have a job? I mean, you slightly touched on this before, like looking at all the options before redundancy.
Absolutely, without a doubt, you can suggest that, and that's the very point, isn't it? That, you know, employers are like, right, next year's looking good, and beyond that's looking good, but it's how do we get through these next months? And if you can offer your employer a lifeline by saying, well, hang on a minute, don't pull that gun on redundancy just yet. I might be able to help you out by going on an unpaid sabbatical for the next 3 or whatever months. Let's review the situation then. That might be enough. So certainly suggest that if you can do, because that may be the solution to avoid a compulsory redundancy situation. So yeah, absolutely.
All right, great.
It's probably worth saying, actually, very quickly, kind of same as with the refund credit note type thing. There's very few, or again, very few, we haven't come across any companies that want to make people redundant. It's this kind of necessary evil of the situation. So Amy and the team here are working with a lot of travel businesses to, and you said the word, Lucy, to find options. You know, how many options are there? What can be done to make sure, as much as is possible, everyone's a winner? And I know a lot of travel businesses, they hate having to make redundancies in any kind of situation. They don't want to do it. But it's
especially if they think it is going to come back, because they don't want to lose the talent, do they? They like to keep these people.
It's the last thing they want to do. So any options that are there, and they're not necessarily palatable, because that kind of situation we described means someone's going for a period of time without wages, and we all need salary, don't we? So, but
yeah, but I guess it's that nervousness that there's not going to be anything else about. So perhaps they would prefer to take no income for a short period if they know the job is still going to be there at the end. And I don't know, but that might be an option for some.
It's that, isn't it? Because employers, if you think about the time it takes to train someone up and the investment time to start from scratch and lose that skill into the labour market and probably go to a competitor. And also the fact of the matter is that, once employees start employment again, they have to wait 2 years before they have certain rights as well. So, if an employee can sit tight, if it means being on paid leave and that accords with their personal circumstances, in the long run, that might be the better thing to do.
Better for both the employer and the employee. All right, well, look, we're on the last question, guys. You've done brilliantly. And it's another employment question, but it's from the employer's point of view, Amy. As a company, we've taken a decision to downsize our office and make more use of working from home as opposed to expecting our staff to come into the office every day. Although we will retain a smaller office for certain client-facing activities so that teams can come in to work together whenever necessary. What legal procedures do I need to go through to make this happen? Do I need to consult with everyone before putting everyone on a new home working contracts? What are my rights as an employer in terms of reviewing remuneration packages if by doing this, my employees incur lower costs in terms of commuting, etc.?
Yeah, I think the fact is that a lot of us have been working from home during this lockdown period. So, certain individuals may say, well, by implication, by custom and practice, the terms of my contract of employment have changed so that my normal place of work is no longer the office, it's now working from home. However, I think most employers have been quite savvy about this and saying this is a temporary measure in line with government guidance, so your normal place of work hasn't changed. To vary any terms of a contract, you have to get agreement and consent. Okay, now if you want agreement and buy-in from the staff to change their place of work, you're probably more likely to succeed on that basis if it isn't coupled with a salary reduction as well. But if you're saying, right, reduce your salary and work from home, you may get some pushback, so you need to think about that.
Well, that's quite a hard pill to swallow, isn't it? I mean, I appreciate what they're saying. They're thinking, well, if everyone hasn't got those commuter costs, can they pay you less? But that's a tough one.
This is true, but this moment in time when the job market isn't great out there, the economy apparently is going to be suffering. People are going to be quite precious about what salaries they earn, and to reduce that salary for the sake of doing a commute probably doesn't outweigh the benefit. I don't know, but it's on a personal basis, and you're going to have to get consent with the staff for that variation.
All right. Okay. Well, look, that is all the questions we've got for you today, and great presentations at the start as well, guys. I've learned a lot. I said that before. I really have. I'm sure other people will have done as well. So, unless anyone's got any final comments, I don't want to cut you short. If anyone's got any final comments, please feel free.
No.
I would say one thing actually, which is that we've talked quite often about giving information to consumers and so on. For those of your viewers and readers who are members of ABTA have got developing a country reopening guide on their website. So that's a resource that can give you a lot of information. And for those who are not ABTA members, the EU have got a thing called Reopen EU on their Europa website, which also has a lot of useful information. If you're wondering where to get all this information from, those are two potential resources. Thank you, Lucy.
Yeah, no, great. That's really useful. Thank you, Stephen. And thank you so much, guys, for your time. It's very kind of you to give, as we've been sort of promoting this as free legal advice, but it's absolutely invaluable. So we're really grateful. And maybe, I think I said this before, maybe we'll meet again in a month or two to see where the industry is, and we'll have another session like this. But for now, thank you to Matt and to Amy and to Stephen and to Christine from Travlaw.
Thank you.
Thank you.
Thanks, guys.